Yes, good morning to everybody. Welcome to the today class of the defamation. And today is the last day where I want to go to teach you the defenses and some of the cases also I will discuss in the class. And please listen to me, no murmuring. And that is the thing which I want to make it out. Yes, the Beda Jonathan Amuli case law is a very important case law because the word should be a defamatory. Whether the word should be a defamatory or not, it will be studied over there. What is the inner meaning is there. And this Beda Jonathan Amuli is an architect and he studied in the Israel Institute of Technology. And he is a 9th or 10th among all the architectures in the Tanzania. And I don't know whether how many could know he is working with a big company. Of course, you need not to worry about what is the company name. And there in Israel, later on, I don't know whether you know or not, Kilimanjaro Hotel, and they got the contract. So he was sent over here for the Kilimanjaro Hotel to take care of it, and it is constructed. Later on, he worked on behalf of the company in Tanzania. Later on, he opened his own firm, and he was the architecture. I don't know whether you know it or not, Kariako Market. Who is the architect? Kariako Market. It is nothing but Beda Jonathan Amuli. And he constructed, he gave the design. And NBC Training Center in Iringa, now it is given to the Ruku. And it is he who constructed that architecture. He. But anyway, in Matanzania, is it Matanzania? Let me scroll it. The newspaper is Matanzania. There is an article which is published over here, and because it is in Kiswahili, Ilario will read it. Whether it is amount to defamation or not, that will be seen in this case law. You hold this case law, Ilario. Because what is cited over here is, yes, let me just wait because I want to scroll it. In Tanzania, that is the given. You stand up here and you hold your mic and you hold this thing too and read what is given over here. Kiswahili. Read and scroll it. Read loudly. From where? Kiswahili. Then you scroll it. I will hold this one. Yes. Read it sound loudly.
Soko la Kariakoo lilichorwa na asiye na elimu ya usanifu.
Yeah, down.
Soko la Kariakoo lipo katikati ya eneo la Kariakoo jijini Dar es Salaam, kitalu namba 32. Limepakana katika muungano wa mitaa minne ya Nyamwezi, Mkunguni, Swahili, Sikukuu na Tandamti.
Scroll.
Meneja mkuu wa soko Kuboja Ngungu anasema mchoro wa jengo hili ulibuniwa na Mtanzania ambaye hakwenda shule kwa ajili ya usanifu wa majengo. Anaishi maeneo ya Kigamboni, Dar es Salaam.
So these are the words which are published in the Tanzania, if I not be mistaken. And who's the chief executive officer? He is the person, and who is the first defendant? Publisher is the second defendant, and the reporter is the third defendant. And he filed a case against the publisher. The words which are made over there, whether it is a defamatory or not, because it's in Kiswahili. Is it a defamatory words? Sema. So, at the time, Judge is Ibrahim Hamisi Juma, now the Chief Justice of Tanzania. At the time when I joined in the UDSM, he was the dean. He was my dean. And he gave the judgment 40 millions as a compensation and 5 millions as exemplary damages. And total 45 millions damages are paid because the words are defamatory. The case law name is Beda. What is the name of the case law? Beda Jonathan Amuli versus Kuboja Ngungu and others. How do you pronounce? Kuboja
Kuboja Ngungu and two others.
And they are the Kuboja Nungu is a chief officer of the a committee, that is a Kariako committee. And one and the other publishers are two. The 45 millions as a compensation which are paid by the chief executive officer and who made such a defamatory statement in the Tanzania. Is it Tanzania? Nini? No, that is the M also there. M is silent. Yeah. Masnifu Mazengo in Kiswahili. Masnifu Mazengo means architecture. So he worked in the Zavet company in the Israel. And Kariako market was, he was the person and who is the architecture. And I don't know, IFM building. Did you see IFM building in Dar es Salaam? And he is the architect, the person, and who studied in the Israel architect. And he is one among the 10 in Tanzania. So the word must be defamatory. That is a very important factor. So this is the case law which I want to share. Then when you matter come to the, there should be damage happened to his reputation. Is it not the damage is happened to the reputation? He is a very reputed. Do you have Cisco WebEx? Do you have Cisco WebEx? You are looking at the smartphone. If you have the smartphone, yes, you can see my, what I shared the screen. You can see it. So it is recording. Two participants are waiting in the lobby. Okay, I will make them to allow. Okay, Karibu Sana. Because I know that who are there in the lobby, I can see it here. And is Magese Atuman, yes, admitted. You can also Karibu Sana. So they could see my screen. And the Suleiman is joined. Remigas Gospel, Rafael is joined. Magese Atuman is joined. Ezika Mombena was joined in my class. In my room. Okay, let us come to the what are the defenses. And I told you the 4 ingredients already. The word must be defamatory. Now the case law you can cite it. This case law you can cite it. This case law you can cite it. You mute it. I am getting the resound. Those who open it, mute. Magese Atuman, mute. Remigas Gospel, Rafa, mute. Mute, because I hear your voice. I could hear your voice. Resound I will be getting mute. I said, mute. Izaki Mohammed, mute. Remis Gospel, mute. Please mute it, otherwise I am getting the resound. I get the resound here. I could hear it, what they are speaking. Yes. When you want to speak, when I say unmute and speak or unmute and read, then you can read it. Okay? Remegas Gaspard, I could not see your microphone. You log out, again log in. You log out and log in. Okay. Now let us come to the point. And I already told you Chimala Stores case law. Chimala Stores case law, if not, okay, I will come to the point. In defenses, truth is defense, no doubt. But if you repeated the truth in the public several times, that means you have the bad intention. Malice, M-A-L-I-C, malice. At that instance, truth is not a good defense. Yes, I admitted, Martin admitted, okay, no matter. So, truth is a defense. One of the case law I cited here, and you can see the case law name, but I will give the facts of the case law. But you should remember the case law. And that case law says, I posted it, the case law in the attachment. It is a truth. A person traveled ticketless. Ticketless means without ticket. Mute it, I say. Gabbat Raphael, you mute it. I am getting the sound. So these people are not that much habituated. That's why They could not make it out. Mute or unmute, they did not know it, it seems. Okay, I will admit you, just a minute. So, a person without a ticket, traveling in a train, I said mute, otherwise I am getting the sound. A traveling in the train without the ticket. And he travels so many times, then he is caught out. What the railway company did, they punished that man with some money and 3 months imprisonment, 3 weeks imprisonment. And they made a circular, 2 months in imprisonment they made it. The railway company circulated the tangazo and with his photo and kept in certain railway stations, main railway station, junctions. And he saw it, his photo and fine and imprisonment of 3 weeks. But actually, he was imprisoned for only 2 weeks. And he filed a case against the railway company stating pay the compensation. But the defense taken is, yes, he traveled ticketless, true, and he was caught out many times, true, and he was fined, true, and he was imprisonment only 2 weeks. But in Tangazo, it's 3 weeks. But doesn't matter, because either 2 weeks or 3 weeks or 1 week, he was imprisoned. So it's the truth. It's the truth. Hence, it is no more a defamation. It's no more a, but they kept in the railway station only, the Tangazo. They did not publish in the Monanchi, Guardian, Matanzania, other newspaper. If they do so, they have the malice. They have the malice, bad intention. So that is the case law that you can cite it for the truth. And I also told you that in the class, you cannot call a prostitute as a prostitute, because every prostitute have a dignity, and hence prostitute having its own name, then you are not supposed to call, even though it is the truth. So truth is not an absolute defense. Truth is a relative defense, depending upon the factors are concerned. That is number one. Number two, okay, you are admitted. Just a minute. Number two, fair comment. In fair comment, I already told you that what is fair comment. Chaggas are janjasana. Chunabuzi chagga. So, is it a fair comment? It is not pinpointed to say a particular chagga. But indirectly it is conveying a particular person. At that time we can say, I say mute, Joseph Sakuru, mute. I could hear your sound here. M-U-T, mute. There is a 2 buttons are there. One mute, one is unmute. Again he is speaking. Joseph Shukuru, I can get out of my lobby. I can take you from my class if you again don't mute it. Okay, now come to the point. It's a fair comment. Lawyers are liars. Liars are liars. Muongo in Kiswahili. Fair comment. No one can be pinpointed. This is a defense. Mouth is not a pen holder. Same he kept the mouth. Why do you keep the mouth? Not only many people. Is it a brush? Sir, I don't have a pocket like you. Hold in the hand or in the wallet you can keep it. Or you keep it in Dani. Amna Shida. I don't see. Okay, come to the point again. Fair comment is a very important factor. But if you say, Mukonono advocates are liars, yes, it is amount to defamation, because in Mukonono and Mukonono, what do you say? How do you pronounce? Mukonono and Mukono. Mukono and Mukono. Mukono and Mukono, firm or lawyers, yes, it is amount to defamation. See, this is a darasa. Hence, I have taken an example. I don't have any vengeance with any firm. And just for the explanation I am making, but it is the amount of defamation because either one lawyer can file it or jointly they can file it. It is a defamation. It is not a matter of fair comment. Now, Sikaliza, Matandio. I'm not Matandio here. He is only having like this. Koyafar. King Reza will say Koyafar. King Reza. I don't know how do you say Kiswahili. Okay, come to the point. The third defense is absolute privilege. In absolute privilege, no case will be entertained. No case will be entertained. Who are having the absolute privilege? Parliamentary proceedings and court proceedings, speaker, ambassador, president, diplomats, high commissioners, they do have a privilege. They can use the language, whatever they want. And it is not amount to the defamation. Absolute privilege is there. And a qualified privilege is, yes, in the qualified privilege you can cite Chimala Stores case law. Chimala, I gave the case law. In the list of the case laws are there. You can download from the net also. Yes, it is there in the net. Chimala case law. Chimala Store case law. CHIMALA. That case law you can cite in the qualified privilege. And PM Atuman Khalfan versus PM Jonathan. Atuman Khalfan versus PM Jonathan case law is there. One is the High Court case law. Another is the Court of Appeal case law. In the qualified privilege you can say it. Now let us see the Chimala Store case law. In the Chimala Store case law, he is a store watchman, a store manager, you can say. But there are some copper wires are disappeared. And there was an allegation on him. And he was suspended also. And his photo with a writing is posted on their branch offices, circular. And he filed a case because he did not stolen it later on. If the case is filed and he is free, and he filed a case against the company, and the company made the allegation to me that I am a thief, but it is not. And the company has taken the defense that qualified privilege because we did not publish in the newspaper. We put our circular in our branch offices, and hence is the qualified privilege. That is a Chimala Store case law. PM Jonathan versus Atuman Khalfan case law. And one is the fellow, I think PM Jonathan is the judge. And Khalfan is the plaintiff. Please, subject to the correction. And he made an allegation that a superintendent has taken the bribe where he is the judge. So he is having a doubt that he may give the judgment in his favor because he took the money. So he wrote to the Chief Justice of Supreme Court of Appeal, sir, I do have doubt and suspicion that the judge might have taken the bribe and he may give the favor. Hence, my case should be shifted from his bench to other bench. My case should be shifted from his bench to other bench, or other judge may be appointed, or my case should be shifted to other judge. And he wrote a letter to the Chief Justice of Court of Appeal. And PM Jonathan, and he is a judge, he felt a defamation and he filed a case against the person. But the court has decided he wrote to the Chief Justice, but he did not write to the newspaper. Are you following me? And Chief Justice is the person who can take the action. Suppose if any matatizos are there, problem is there, to whom you approach? Your director is there now. Postgraduate studies, undergraduate studies, head of the, first you approach to the head of the department, from the head of the department to the dean, from the dean to the director of the undergraduate studies, from there DVC, from there VC. Are you following me? So this is the hierarchy. This is the hierarchy. And with that you have to follow it. And they wrote to me because I am the Chief Justice, and hence it is not amount to the defamation. If the qualified privilege is there, one can write it. Because he is having the doubt. So that case law also we can cite it under the qualified privilege. and public interest. If any public interest, if you published it, yes, it is not amount to defamation. It is not amount to defamation because it is the truth. It is not an allegation. It is a truth only. So when the truth is there, you can make it out regarding the public interest. That is a very important factor. Then what is public interest? Again, the question comes. What are the factors should be there in the public interest? So I already given the posted you. These are the factors are there to make it a public interest. Number one, what are the factors? Of course, there is a Reynolds versus the Times newspaper limited case law is there. Seriousness. Seriousness of the matter is a very important when you want to publish a public interest. Number one, seriousness. Number two, subject matter. Subject matter is such a way it is applicable to each and everybody. At that matter, subject matter could be a public interest. And source. Well-sourced information is more likely to be protected. What is the source of it? Documentary store, or there is a CCTV footage, or there is a video, or there is a tape recorder. So source is very important. And whatever the sources you got it, and you have to verify it. Without verification, you are not supposed to publish it. So verification is very much important, and status also is important. Information which has already been subject to another investigation is more likely to be true and so more likely to be protected. Status of a person also very important factor. And what is the urgency? Urgency is one of the factor to say whether it is a public interest or not. So that is a very important factor. Then comments from the claimant. The claimant made. Claimant means plaintiff here. Suppose the other person will say, Nimesahav, not Nimesahav, Samhani, excuse me, I beg your pardon. If you are happy, okay, that is a defense, justification. If you are not happy, yes, you can file a case. Or in the newspaper, they will make an apology. If they make an apology, if you are happy, well and good. If you are not happy, you can file a case. So that is also apology, also a defense. And then we can say, and tone also very important factor. Here tone means the way it is expressed, the language is used is very important factor. The language is used also. Samatra Peter, mute. Marcus Atman, mute. Because I could say they are murmuring. And circumstances. What circumstances made you to public interest? Circumstances also very important. Depending upon that, we can make it out. And I told you that fair comment, honest opinion. Honest opinion is a justification. And it is not amount to any other thing. And the later comes, yes. I told you website. In the website, somebody posts it. The person administrator is not responsible. No. Because we do have case law. Information Technology Act, Section 66A in India is struck out. If any matter is posted by any other person, and if you are the administrator, or if you are the, source, or server is belong to you, somebody is posted in that server, any defamatory matter, the server owner is not, I don't know whether you know the server. Najwa server. Najwa. Server means it will store it, it will cast it. It's a branch, telecast branch, server. Through that server has come. Because each one having, you ask the IT man server, South is having their own server. All data will be stored over there. And it will be passed over there. So server, and he will not be held liable because it is posted by somebody else. So it is not amount to a defamation to him if anybody made. But one thing is true. Suppose if bullying is there or stalking is there, I don't know how many people know. Cyber threats these are. Bullying or bullying. BULLYING. Bullying or bullying, stalking, squatting, and hacking. You know hacking? My email is hacked, will say. Yes, these are all comes under the both civil as well as the criminal one. And if you enter into the privacy, yes, you are not supposed to do the privacy of anybody else. And you should not disclose the privacy of any person. It's amount to defamation. If a person does so. If a doctor, he could not reveal who is having the HIV and who is having the UKMV. Unless, suppose somebody came to give the data to him, yes, at that time he can tell the truth. Otherwise, he is not supposed to tell the truth. And for every case law, there is a limitation period. Limitation period. If once the limitation period is over, you cannot file a case. Only your remedy will not be there, but your right still exists. Your remedy will not get it because you cross the limitation period. What is the limitation period in the contract? 6 years. Limitation period for the accidents, it is 3 months, sometimes it is 1 month, depending upon the nature of the accident. And that is another point. Limitation period is also one of it. In the limitation period, your right is right, it will be there, but only remedy is removed. Remedy only removed, but the right still existent over there for the limitation period in the defenses in the defamation is concerned. And suppose, I say suppose, don't think that, sir, why you are taking my example. Suppose, if I write to him about her, if I write a defamatory matter to him about her, and she does not have any knowledge, whether it amounts to defamation? One point, he will go and reveal, so-and-so person wrote a letter to me that a defamatory about you, and she later came to know, yes, it is amount to defamation. Suppose, report me, in Kenya, newspaper published a defamatory matter, and I don't know what is published over there. But somebody called me, for you, a defamatory matter is there, so now the media is there, social media, he will take the screenshot and will send to me. I can file a case against the person if it is a false. Even though if it is the truth also, what is the intention? Am I a public figure? Am I a public figure? Am I a public servant? I am working a private. And what way interest? Malice is there. Bad intention is there. Hence, it is amount to defamation. It is amount to defamation. And in my case laws, when I dealing in my article also I have given, a letter is thrown into the house and a butler opened it. Servant, butler means servant opened it and he read the letter and he sealed it and kept it on the table. And he never revealed. But we can take an action against the butler, but it is not amount to defamation. Even though he read it, but he did not disclose, he read it because it is addressed to a particular person. And it is a registered, it is a letter. Registered letter will be delivery, will be given to only the sender, not sender, addressee, to whom it is addressed to. So at that instance, we cannot say it is a defamation. So in this way, there are defenses are there where we can say whether it amounts to defamation or not, and how it will be a defamation. And the defamation, you need not to take a particular person name. You need not to take. Suppose if I say in the class, a tallest man, his brain is not in the Kichwa, his brain is in the goatee. I am definitely there will be one tallest man in the class. And it refers to him. How could you say his brain is in the goatee? Goatee means King Reza. Spelling. It will be recorded. If you say meow, 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 it will be recorded there. Say in a sonorous voice. S-O-N-O-R-O-U-S, sonorous voice. And I I told the Hilario to post you in your group WhatsApp my 10 commandments. My 10 commandments, it is there. Please read and come to the. Everybody should have to sign. If anybody has not signed, please take the paper and sign it. And the mood of Caribbean. No, still we have 10 minutes with us. Yes, still we can discuss something. So, in this way, the defenses will come, but the scenarios I have given, yes, I'm not murmuring. Sikiliza. So, if you say a person is a kipara, yes, you are not supposed to say, no, everybody knows that is a kipara. But what is the intention to say kipara? You are having the bad intention to say kipara. Can't I know that he's a kipara? I know it. It is amount to a defamation because the intention is, your intention is bad. Oh, Rambo, how are you? She is like Imka. Still I say Rambo, but it's a black beauty. It's a black beauty, black diamond. So it is not amount to defamation. Ndevu, Nazuri Sana. It is not amount to defamation. But if an allegation is there and everybody heard it, yes, it is a defamation, even though it is oral. Even though it is a oral, we can make it out. So how you can say, that is also very much important factor. Your tone, your words are important factor. So if a public figure is there, a public servant is there, and you do have every right to criticize him, because if you use it, misuse it is the fun. Sister, Simba Haba Ipo, we are murmur. So don't speak, don't speak. So how the words are used are there very much important factor. And opinion, no defamation. If you pass an opinion, it's not amount to defamation. And once you can make the defamatory statement to a public servant, again I am getting the murmuring sounds. Just before your pin drop silence. Now again you started. You can make a public servant or public figure, yes, you can make it criticism against him, but you cannot make his affairs with the secretary. That is salarious, I told you just before, salarious statement saying somebody's about the sex life and which is not needed. If you say the sex, I don't know whether you know, is a Monica Lewinsky, the American president. Did you hear that news? Monica Lewinsky, and they have the sex scandal with the American president. I think, sir, we have not born at the time. No, it's not that much old. Affair with somebody else, you cannot make it out. It's the amount of defamation. It's the personal. But according to his post, for the function, you can make the statement. And that is a very important factor. And in this case law, I would like to say Pullman case law. There is a Pullman case law is there. I have given and I sent to you in the email, Pullman. Yeah, Pullman case law. I would like to share because still we do have time. No murmuring. In Pullman case law, Pullman versus W. Hill and Company Limited, 1891, 1 Queen's Bench, 524. That is the way of. Okay, I would like to say, Andika, Pullman versus. Mute. I am getting the sound. Pullman versus W. Period. Hill and Company Limited. First day you can say like that. Now also you say the same thing. Pullman versus W. Period. Dot Hill and Company Limited, 1891, 1 Queen's Bench, 524. Do you know why I dictated you? Nobody can write in a correct manner. Open challenge, it is mine. It is my open challenge. Nobody would write correctly. Because I know your pulse, your depth, how much the knowledge you have. Sister, Ukavapi, did I say Pullman case law? I say Pullman versus W, Nini, W and Hill. Where is Hill? A sister who sat in front of me could not write properly. How could I expect that the person who sat at the back will write properly? Hapana. Hapana. H-A-P-A. H-A-P-A-N-A. Hapana. Bold. Center. So, I know that you cannot write it proper way. Even a Pullman versus W. Hill and Company Limited, 1891, 1 Queen's Bench, 524. Mute. I can challenge it. You cannot write it. Oh, he moved the video also. Toleta Matubas, listen. Don't keep the run the video. Mute it. The defendant, I said a mute. Kijiji too. You don't know how to operate. I said mute. I will get the resound. And you will hear Kijiji too also. There is two buttons are there. One is mute, one is unmute. When you speak, you unmute it. When you don't want to speak, you mute it. If you don't mute it, I will get the resound. And whatever you speak, I could hear it. So, a defendant dictated a defamatory statement to the secretary in shorthand. And secretary made a longhand and given to him. And it is posted to some third person. Yes, it is amount to defamation. Because secretary heard it. Secretary came to know about the defamatory matter addressed to the somebody else. Yes, it is amount to defamation. If you dictate to the secretary in the shorthand, she will write it. Later on, she will make the longhand and he will give it back. It is posted on it. Yes, even though to whom it is addressed, he doesn't have the knowledge, but she is having the knowledge, and it is amount to defamation because it is a publication. So that is the thing they said. And the letter was sent to the claimant and then opened by one of his mail room clerk. Doesn't matter. The claimant brought a case of defamation against the defendant on the basis that this constituted a publication. Because even though the mailman opened it and who is in charge of the store, it doesn't matter. But it is dictated to the secretary, yes, it's the amount to defamation. And it is the amount to defamation also. Because a letter is addressed to a particular person, at that instance, even your wife or your machumba should not supposed to read it when it is addressed to you. So one of the case law, we studied it. One fellow dropped the letter to her wife, to somebody's wife, and the husband came and husband opened it and read it. Yes, it is amount to defamation. Because in the house, the probability is that it is not a registered letter and it did not come with the post, and hence there is a possibility that any person could read it and husband read it. That is amount to defamation, we can say. So muda una karibia, muda imisha, and how this way we can say that how a defamation will work over there, and we studied. With this, I would like to close down my recording, and this I will send you in the YouTube. Everything will be audible to you, and even the way which I spoke, it also comes to you. Karibu sana, asante sana, Mungu akubariki na kukalinda. With this, I will stop my end of the meeting. Yes, end meeting. Sawa.
Wabariki